I did try to go with the bigger screen. It won't let it. It's interfering with Telegram somehow. So that's about, I can try and make that window bigger. Give me 1 second.
That's awesome. Thank
Okay. I don't know if I can control the screen here though. I don't think so. All right. Can you still see the screen?
you. Absolutely, yes.
Okay, great. All right. We're going to get started. What's that?
Can you close the properties pane on the right side where all the layouts and the slides are shown?
There you go. How's that?
That's better.
Okay. And you guys can hear me okay?
Yes.
Perfect. All right. I'm going to ask everybody to mute out, and I'm going to get started, and we'll go through here. And I'm going to reintroduce myself briefly. Just my name is Dave Horowitz. If you haven't heard the first call, the recording is in the group, and you can re-listen to that. I don't really want to spend a lot of time on on going back over who I am and what I, how I got to here. But the recording is in the group where we're chatting here now. Please, if you haven't heard it, listen to that one as well. And we'll have some questions at the end. And hope what we talk about helps you. All right. So administrating your trust estate. All right. It's from public to the private. Okay. Last week we talked about establishing your trust estate and putting together a series of trusts that, assuming that you would go through that course and get into the second part, administrating your trust estate. And this course is designed to do exactly that. Provide you with the tools and the knowledge to administrate in equity the things that you have entangled yourselves with in the public. So going from establishing your trust estate to administrating your trust estate, this is where, the work starts. The other part is organization. This is definitely where the action starts. Okay. With ownership. Okay. When you're the owner, right? With ownership comes responsibility. Okay. When you start to administrate your estate, okay, we've done a lot of the establishing, and this is where I would say definitely, if you haven't heard the first call, listen to the first call. We spent our whole lives amassing stuff, relationships, and we haphazardly administrate day to day, unknowing that every relationship is a trust, whether it be with things or with people, corporations, right, or with other men and women, children. But we never looked at it in a way to kind of like put each thing in its own filing cabinet, and this is where you would start to take back, move, right, convey those things that the public has been administrating over, including yourself, and move those things to the private where you're the highest authority. Okay. So it's not about paperwork. It really isn't. If you know how to express your trusts, um, that's way more powerful than a piece of paper. Okay. That doesn't mean that you don't have the paper. Okay. Paperwork is evidence in flatland in the world that, we've been subjected to. It's all about paper. Okay. Legal fictions are just that, paper. Okay. So it's not about paperwork, though. It's more about the authority, right? I mean, how many of us have felt like, a beggar at the system's door, you know, having to get handouts from the state, and having them administrate over every aspect of your lives. You're not a beggar, all right? If you set up your trust estate, you're organized. Now it's time to start the work. Okay, you administrate your trust estate. Those trusts you set up and quit claimed properties into, now you have to send notice. So administration. Okay, so what does it mean to administrate your trust estate? Management. If you've got business skills, if you've managed a business, your own business, it's not much different. Not much different, except you're managing uh, multiple, right? It's organizing pretty much every aspect of your life in a way that you can present it as evidence or, just to correct the records. Okay, so active stewardship of what you've been entrusted with. You're the one that oversees it. You have to account for it. You need to correct and to protect it. The record, correct the record. Okay, and to protect the assets, the the subject matter that's entrusted to you. You don't administrate it, someone else will. That's evident, it's pretty self-evident actually, because every day you see it in the public. It's getting administrated by, you know, public trustees that you wouldn't trust in the same room with your family members. So in the last call, we talked about, first step is getting your inventory together, right? Being able to uh, basically inventory the things that have been entrusted to you. If it serves your estate, great. Keep it, take care of it, be a steward over it. If it doesn't, get rid of it. Sell it, help somebody else with it, whatever. But if it's more to manage, it's, more of your time. Okay. Especially if it's a thing. Okay. The inventory list was not just of things, it was also relationships to be able to, um, you know, identify heirs and beneficiaries and potential trustees and things like that from your current or future relationships. Okay. Every property, policy, registration, or license, every contract that you have set up in the public is a trust. Every time you registered something, you set up a trust with the public. Registered a vehicle, they hold legal title and most likely have as long as you've owned it and the people before you owned it and before that. Okay. They keep very good records. Those are administrative records. That's part of something that you're going to look for in an accounting, and we'll get to that. But every property, policy, registration, license tells you who is in control of what you think is your stuff. Who holds legal title and who holds possession, right? We talked about the grantor of the trust. That's the one who creates the indenture, the rules, right? Then you've got the trustee, the one that the property is entrusted to, right? And then you've got the beneficiary, the one who's using the property, or benefiting from the property, right? So if the state or the crown or wherever you're at, if the government is holding legal title to your property that you've registered into their public trust, okay? They're holding the trustee legal title. They get to make the rules, or they get to enforce the rules. I don't really want to get in too much to uh, dissecting the political spectrum, but supposedly you have representatives, right? Supposedly, I don't remember signing a power of attorney for anyone to represent me, but they say this one represented you. That was the one that brought the bill, right? Everything goes before Congress as a bill. It's a bill in equity. It has to be considered. Well, another person calling themselves your representative actions on the other side of the coin, right? They playing ping pong with themselves with this bill. One made it up. They all made it up. Kick it to one, to somebody else. It's considered, right? Two witnesses binding, and then who's bound? Oh, all the legal fictions are going to pay for that bill. That's where the debts come from. Anyway, when you get to who holds legal title, you go back through when you're doing your inventory. Okay, who issued your birth certificate? Who issued your social insurance number? What trust is that, that you were registered into? If you registered for a license, or registered a vehicle, or registered your home in the the county tax rolls and the state tax rolls. Okay, all of these things. If you registered a business, those are all contracts. Anytime you register something, you're creating a trust. You're splitting the title. You're no longer the owner. You're just the user. You are the beneficiary, the equitable title holder. All right. So who holds legal title and who holds possession? If your private trust holds both legal title and equitable title, because it was quit claimed, and actually the beneficiary of that trust would be the one who holds the equitable title. Okay. But the trust has possession of the actual property. Okay. Then basically you would be free from being managed by the public. Okay. If you hold possession, but the state holds legal title, you're just taking care of it for them and actually are acting as a surety. Okay. It's upside down, right? Those are supposed to be your servants, that your trustees. Okay. And this is why trying to take these people to legal courts rather than doing a bill in equity, okay, or a claim in equity, you're going after them with lawsuits. I want this, I want that. Equity does what's supposed to be done. All right. So we try to flip the table, okay? So just think about all the contracts that you created with the state or the government. Every time you signed, okay, it's evidence of a trust relationship. You signed a mortgage, a promissory note, created money in the system, right, with your signature. You apply for benefits, right? He who accepts the benefit bears the burden. And when you go to get those benefits, you may as well be Oliver Twist, begging for some more. They're not, they're not big. You may get a few food stamps, but it just shows that you're dependent. Okay. All right. So basically, when you've gone through and established your trust estate, you're now going to start to administrate those things out of the public and into your private estate. Okay. One notice at a time. All right. What's the administrative process? Okay. It's the same process you get that the government's using against you. Okay. Like I said, we're going to flip the table, reverse. They get you to volunteer, taking you from equity into commerce. Right? Private law, we talked about it toward the end of the last call, but private law is the law of contracts. That's covenants. And the law is between the parties to those contracts and covenants. Okay? So the first thing we do is we always send notice of private trust. Okay? Asking them for a full accounting. Now, we're going to get to that in a second. I don't want to jump too far ahead. All right. So first thing is notice. Second is an opportunity to cure. Right? That's called due process. Step 3, default and closure. They either acknowledge it and do their accounting and convey all rights, titles, interests, and assets that they are holding, or they're in breach of their fiduciary duties as the prior trustee of trust property. Because when you established your trusts, you created a foreign entity to that government. It's autonomous. We'll get to that too. All right. Notice an opportunity, due process. Equity demands fairness. Every notice gives the other side a chance to respond. If they fail, equity steps in. Most of you guys have probably sent in notices before, possibly did an administrative process. I don't know. You know, when you do your administrative process, it should be complete. It should be binding on both parties. Should one party fail to, respond, right? They acquiesce by their silence. Anyway, if you've done it and it was ignored, that's fine, all right? Because I don't know if you're familiar with the term by operation of law. It's done because you did it, okay? It's done. And it goes into effect automatically. And it's, yeah, I'll get to that in a second. Sorry. I'm trying to follow along. All right. Second step, giving grace. And it could be 3 days, it can be 10 days, it could be 2 weeks, it could be a month. It's all up to what you want to do. Okay. When you're doing your administration, okay, it is symbolic of a period of mercy before final judgment. Okay. It shows that you act not in vengeance, but in good faith, right? You come with clean hands. These are equitable principles, and there's not a whole lot of them, so they're kind of easy to remember, which is nice. You don't have to remember this code, that code, and this chapter and verse of that constitution, and this local county's rules, and oh, the judge has their own rules. Okay, equity's real simple. Not easy, but it's simple. Final notice. So the first was original notice. Second was a grace period, a second notice, right? Give them opportunity, correct, do what's right. And then you have final notice and equitable estoppel. When they fail to rebut your notice, equity locks in your claim. The record stands, silence becomes consent. And in your notices, it should have a caveat and a covenant if they choose to stand mute. That's how administrators reclaim their estate. There's no fighting. Equity isn't about adversarial proceedings. Okay, you're bringing the treaty. Okay, you are bringing a treaty. If you want equity, you have to bring it. Well, you've offered, you've offered 3 times. When you have gone to the end, right, of your third notice, this equitable estoppel, final notice, by operation of law, they are equitably estopped. Equity won't allow a statute to be a cloak for fraud. All right, moving on. All right. So in your trusts, if you, again, listen to the first call, hopefully go through the first course, get your estate in order, okay? The trusts that we set up through the courses take governing clauses very seriously, show how to use them, how to stand on them, okay? Every every contract you've ever signed has a governing clause on it. Most of the time it says this contract is governed by the state of Florida and the United States. So people are adding the government to their contracts, and there's absolutely no reason to do it. You have a choice of who you get to contract with, period. That's like inviting the government to your marriage bed. And if you've gotten a marriage license and registered with the state, then you got to go through, same thing in reverse, divorce. The state's going to get involved. People wonder, that once they're involved, why can't you get rid of them? Because they've been there the whole time. They sleep in your marriage bed. Every little thing they administrate and keep a record of it. All right, so governing clause, okay? Every trust names its own governing clause. That clause determines which kingdom rules your estate. If your indenture says this trust shall be governed by the laws of the state of Florida, then you voluntarily placed it under the public's jurisdiction. You volunteered. Equity won't aid a volunteer. If your indenture says this trust shall be governed by the word of God as expressed in the Holy Scriptures, and disputes are going to be resolved by private mediation among the trustees, then you've declared your estate as part of the kingdom's jurisdiction under a much higher law that can be used in any court, and I don't care what country you're in. May not do well in every country. There are countries out there that'll kill you for having a Bible. Anyway, hopefully you guys aren't calling from one of those. Anyway, governing clauses, okay? You declare whose law you live under. Okay? It's not rebellion, it's governance, right? Like I said, when you set up your private trust estate, each of those trusts is its own nation or could be tied together by treaty with other trusts. Okay? It's governance. You're governing your own affairs. That's what administration is. Administrating your trust estate is you're governing your own affairs. That simple. Okay. Article 1, Section 10, Clause 1 of the Constitution protects your right to make private contracts that no state can impair. That's in the U.S. A little harder up in Canada. Their constitution up there states you have a right to contract with anyone you want, and anyone you don't want, you don't have to unless it's the crown. But that's, I mean, it's kind of, them saying, they're always safe. They're always going to be part of your contracts. They can't beat the Bible because the crown itself is supposed to be defender of the faith. Okay, so they still recognize they're still subject to the laws written in the Bible. And I can tell you that I've never lost in court when I've had to go in there and defend myself on charges. from the state, I've never lost using the word and using my trust. It's, again, you're walking in. This is, again, it's not about paperwork. The more you understand it, the more it's a part of you, especially your indenture to the word. You can't bring it to remembrance if you don't have it inside you. You don't know what it is. You don't know how to use it. And it's the same with your trust. This is action. This is putting this into practice. Nice to take a course and learn something, but this is a step-by-step way to unencumber yourself from, the state, the ruling class of trustees you entrust in the same room with you in the dark. Anyway, when you insert a proper governing clause into your trust, you've already chosen your court. Okay, venue. You can challenge venue, right? This is the wrong venue for this claim. This is landlord-tenant court, and this is a traffic matter, right? That'd be considered the wrong jurisdiction or the wrong venue. Okay. The court of conscience and equity, not of statute and policy. Statutes, okay, govern fictions. Statutes govern the public trust. They govern the public trustees, just like a constitution is supposed to. Never seen it governing them. It's a piece of paper or a piece of hemp. All right, so governing the clauses, okay, it's your shield. That's your you're picking your choice of law. Okay, that's another challenge. Choice of law. Sorry, I'm not subject to that law. I'm subject to this law, and I can prove it. It sets your law, your venue, and your peace. Again, if you're going to bring peace, equity is peace. We're not going there to argue. That's what they want. Adversarial proceedings. You can argue and complain, and nothing ever gets done. There's never a remedy in that stuff. Believe me, I've been doing this a long time. I've seen stuff work, and then the next day it doesn't work. Anyway, and a lot of you probably have too. So whose law governs your house? Your estate. Whose law governs your trust? When you decide that, okay, you're going to be the one administrating, okay, under a choice of law that you consented to. All commercial contracts are with government by proxy. I mean, anybody that's been in the commercial system at all, can see, right? If you saw the movie The Matrix, right? Anybody can be an agent and go to the corner store and try to buy, a can of beer, right? That 20-year-old kid across the counter turns into an agent. I need to see your government issued ID. Now he's a law enforcement officer, right? All those commercial contracts are with governments by proxy. They registered their businesses into the public trust. Just like having a baby and naming it, you did the same for your business name and created an entity. It's okay, you can make pass-through trust just like you could with your straw man. Business is a pass-through. A lot of businesses you need to have, to get certain contracts, you have to sign up for this and sign up for that. But if your S Corp or your C Corp or your limited liability company is owned by a private trust, it's just a pass-through. Public got what they wanted. They got their, fees and stuff to get the licenses so you can get the contracts you needed. Right? It's administrating at arm's length. And you can set up many vehicles to do that. You can have any number of kinds of businesses, whether they're part in the public or even straight up private membership associations. Anyway, So all these contracts are with the government, every business license, registration permit, subcontracting with the public trust. Okay. Those are all contracts. Did you have full disclosure? Sure. Most folks don't even read the contract. They just want the benefit. So they rush to sign and don't realize what they just gave up. They sold their estate for a bowl of stew. So the state's always in the middle, right? The adversary. What did the adversary want? He wanted to be God. Well, every place that God is supposed to be in the picture, the adversary now is, which is the system, these governments that we all find ourselves dealing with on a daily basis. Right? They put themselves in the place of God. They are judges and lawmakers. Right? James 4:12, there's only one lawgiver and one judge. Who are you to judge your neighbor? Well, if that's true, then who are all these people claiming to be that? Put them to the test. Put them to the test. Did it in a court here in Missoula, Montana. Not going to get into that story. There's plenty of recordings with that story on it. You'll get bored of it. I don't want to get into that. But so all your contracts, okay, the state is standing in the seat of God, right? They're judging you, right? They are basically making up laws and rules for you to live by. Meanwhile, they stand by and they're above them. Doesn't seem right. We don't destroy the system. That's not what this is about. We administrate our stuff out of it. Okay. We just don't participate. We don't accept their benefits, and we don't especially accept their right to manage our affairs. You are the only one that should have the right to manage your affairs. And if you do it properly, you can do it behind a shield of trusts and very little to do with the state. And basically being in the world and not of it, not participating once you walk out of it. And nobody said that walking out is walking out empty-handed. And that's why this course is, there. It's when Israel left Egypt, they took all the wealth with them. Why? Because of all the years of slavery. And you're not taking it all, just what was accounted for in their records, in their administrative records. All right, so which sovereign is the highest authority? Right? Treaty. Sovereigns, right? Nations, they deal with treaties. You set up your trust estate, okay? You're claiming your independence from the state. So, and again, you can do it as much as you want or as little as you want. You can always operate in their system at arm's length, or you can just separate yourself from it, right? So the covenant is the foundation of private law, contracts. Right? This is the covenant I'll make with the people of Israel after that time, declares the Lord. I will put my law in their minds and write it on their hearts. I'll be their God and they'll be my people. Well, if you can't serve two masters and you still have a choice, right? This isn't slavery, supposedly. But you get to choose who you're going to serve. So this isn't about church, okay? It's and coming from a biblical perspective, okay? You're reclaiming your citizenship in a holy nation. Kingdom of heaven is not just symbolic, right? It's jurisdictional. And the covenant itself, cover to cover, is a trust, an everlasting covenant, an irrevocable trust. Right? Philippians 3 talks about our citizenship being in heaven. So it's provable in a court. Absolutely. Unquestionably in most courts, and at least in crown countries and the United States and a lot of others that recognize the Bible as being God's law. It is the highest law, the law of the air, not AIR, the HEIR or HIER. Always get that one mixed up. All right. Religious autonomy. It's not just religious autonomy, it's autonomy. Your trust is foreign to wherever you are. Doesn't matter what piece of dirt you find yourself on. Your estate is foreign to every other nation claiming to, be your sovereign. Right? United States Code acknowledges it. Clergy, churches, synagogues, religious orders are all autonomous jurisdictions. Right? Protected when you operate by your conscience, not by commerce. You can look up the Justice Manual. I've given away for years private notices. People get a hold of me and ask about these private notices, and have used them to get out of traffic tickets and a bunch of other stuff. But they recognize in their Title 115, their respect for religious liberty, and they cannot, by their own rules, interfere with your beliefs, period. So your indenture and identity, okay? Your trust indenture defines who you are and who owns you or who owns the other property that's in there, right? It's your declaration of trust. It's the law between the parties of that trust. When you write it, okay, you get to decide which law governs that trust. The Bible says that we're ambassadors, okay? Ambassadors from the kingdom of heaven, okay? Our job is that word reconciled, right? Reconciling, it's an accounting term. And it's our job to reconcile those things that were entrusted to us.
Yeah, all that traffic over the first few innings, and then he
public.
retires the last 20 hitters.
Reconcile
The last guy
them
to do
back
that
to
in
where
the
they're
World
supposed
Series
to be,
complete
under
game,
the proper
Don Larson.
management, which is you and your trusts. You're the trustee. Okay? Reconcile all things back. Right? When they go and they pass through your straw man trust, you put them in your kingdom of heaven trust, and then the kingdom of heaven trust grants them to you as, or your other trusts to manage. Okay? You're controlling it all. You've written it all. Okay? You've indentured yourself to that law. And it will hold up in every court if you know how to, express your trust. When we go into course, it's not just, here, there's some words on a page. We go through this stuff every Thursday for hours, asking questions and going through and real life scenarios and in administration, as well as setting up your trust. The Thursday call was all three of these courses, establishing your trust estate, the administrating your trust estate, and then protecting and defending your trust estate. Students in all three are on that Thursday call, so you get some advanced knowledge, even if you're not in the course yet. But it's starting to register. There's a lot of that, and there's a lot of recordings already there of those sessions. So you get to benefit from all that as well if you're taking these courses. So reconciliation is our our mission, basically. And ambassadors, those get diplomatic immunity. How's that work? These are questions that we talk about, things that we do actually that are practical, right? All right, so what is doctrine of merger? How do you get the stuff from the public into the private? Okay, so the doctrine of merger. I have students on this call, I'm sure, that can answer that. But the doctrine of merger, if you are the beneficial title holder or the equitable title holder, and the state is holding the legal title as trustee, okay? And if you back up a step, before you registered your property and created the trust itself, you were the grantor. So you went in and granted them the title to the property. And what they did was split it between you and them. They hold legal title. They can manage you, micromanage you, fine you, fee you if you don't follow everything in their code. Okay. And you got use, a title that you could sell the use of it, but you don't have ownership. You only have half a title. It's the best half to have if you are the beneficiary, okay, because the beneficiary is looked at as the true owner of the trust property. So the doctrine of merger says that when the equitable title is in the hands, the equitable title and the legal title are in the hands of a single trustee, a single party, okay, whether it's a trust, a trustee, or the beneficiary themselves. Right? You could show up without any trust set up and merge your title. I've done it in court with my son and his friend in the federal court in Las Vegas. But just by taking their birth certificates into the court and handing them both to the judge. It's a hot potato. It is a hot potato, especially if you're handing it to one of the trustees of the trust, one of the people that is authorized with the legal title. When those two things merge, it collapses the trust in one hand. So they don't want to collapse it. They couldn't. They could, but they get in a lot of trouble because they're not the beneficiary on the document, right? Judge doesn't want to hold that. Prosecutor sure doesn't want to hold it. But the doctrine of merger is having both titles, right? It collapses back into a single title or a lodium, right? By operation of law. So when legal and equitable titles merge, the trust collapses. So does the public's claim to administrate your private property at that point. So operational law means that it happens automatically once certain conditions are met. That's what operation of law means, and that's how we use it. How do you perfect your administrative process, right? Notice and acknowledgement. You put the whole world on record that you know who you are, what you own, and under whose authority you act. All right. You've done your notice, you've done your grace period, you've sent in your final notice, and now they are stopped. Stop means they forfeit, okay? They basically didn't stand up and answer. Kind of like a quiet title, if anybody's familiar with quiet title actions or declaratory judgment act. These are things that we talk about more in the next call in defending, okay? But this is like the step prior right here, right? They're stopped. You've already done your administrative process. They forfeit. They no longer have a claim, a right. You file your bill in equity, not a complaint at law, okay? trusts are governed by equity. It's private. It has nothing to do with the statutes and codes. They do not apply to your private trust. So I believe it's the PPSA in Canada, UCC, Uniform Commercial Code here. All right. It's the system's language of who owns what. Okay. You're not registering anything. Okay. You record, use it to record the liens, right? The relationships to property, the liens by your trusts, right? It's not a request. It's not creating a trust. It's how the private communicates with the public when it comes to property liens, who has the highest claim. All right. You get to choose. Like I said, I mean, you could literally kill off that straw man utilizing your administrative. These guys, if you would, just mute out until I'm almost done here. Then we'll have some questions. All right, so you can also operate it at arm's length, be able to set up businesses and have a business trust that use it as a pass-through, same that you would do with your straw man, okay? You can manage it without being enslaved by it. And that's what we want. We don't want to be we don't want to be the surety for it. We've been doing that our whole lives, right? We're the ones that eat the fines, and it's our energy that pays for everything, and yet you never own anything, right? You're always a tenant. Well, don't believe me, look at your deeds. I don't care where you're at. Here in the US, for sure, most of your deeds say that you're a tenant, and you thought you owned it. So equity will not aid a volunteer. If you signed up, you've ever heard the term buyer beware? You bought it. You sold your soul to the adversary. There it goes. Right? Every signature you ever signed with them, okay, was a trust. So I know it's evil. It seems evil at the time, dealing with the system. Really, what is it? It's a bunch of people just administrating their job, their own little job. Most of the time, you can get much more evil. There's a lot more corruption there, but at the everyday level, that's what it is. It's people just administrating little cogs in a wheel. So every signature is a covenant, and you can cancel what no longer serves the trust, kind of like what we were talking about in your inventory. You can remove real property from the public trust, refile the deeds properly, convey it into private trusts, and remove them from the public registry. It's all part of the administrative process. Going through the course, you get all the templates and everything, and instruction. Plus, we discuss it Thursdays. Literal. I wouldn't say one-on-one mentoring, but there's tons of opportunity for that as well. But which will be by appointments. But anyway, basically, that's what we want to do. We want to remove the things that were entangled with the public and remove them into our own private trusts, our own estate. So you're looking at DMV, the IRS, the CRA. Where did you go to school? Because you registered for those public schools and those colleges and institutions, right? You registered your businesses and your marriages and your children and all these different things. Okay? All those contracts have to be administrated out. So you, at the very least, gain control over all of that and the record that was going with it, the administrative record. Social Security, so the trust, it's their accounting system. It isn't your master, neither is the IRS or the CRA. The president, the crown, doesn't make a difference who they are. None of them are God. Put them to the test if they claim it. Can they walk on water? Turn water into wine, raise the dead, any of those things? If they can't, then they're nobody. They're just another person. Right? We're supposed to be all equal. At least that would knock them back down to, at the very least, your level on equal grounds. Right? And that's where you get back into treaty. So every act that you volunteered in, registering to vote, licensing, pledging children, all of it, you can rescind it. Okay, you're basically restoring order, right? Reconciling things back. The records, all those records are part of the accounting and things that have to be accounted for. The only thing I want in my records is no longer hold subject matter jurisdiction. That's it. That's it. Demand your full accounting and conveyance. When you use that doctrine of merger, it creates an operation of law. Okay, you merge the two titles, equitable and legal, into one entity. When you quit claiming it into your private trust, it goes from the trust and the public to the private. You didn't have to go ask permission to do it. You just did it by your own action, your own deeds. I don't have it on the slides here, but if you get a chance, look up counter deed, COUNTER deed, in a legal sense. You can Google it. Somebody looks it up and wants to go over that here in a few minutes, we can do that. I only have a few more slides left. So, trust administration do's and don'ts. Do everything in honor. Don't argue with the public, right? They want you to argue. We're not to be adversarial, right? We're supposed to be ambassadors of what? Peace. So we bring a peace treaty. Hey, I won't accept your benefits if you give me back everything you stole. Heck, I won't even judge you to be accountable unless you don't perform what you're by operational law required to perform: accounting and a conveyance of all rights, titles, interests, and securities and bonds and any other assets that they're holding, along with the entire administrative record. I'll hold you harmless if you can just do your job. Don't act like the debtor. You're not a debtor. You're not the slave. Okay? Is there any truth in legal fiction? There is no truth in the fiction. Very, very limited amount of truth, more indoctrination than truth. But the fiction itself is a piece of paper. Not evil. It's the people's intentions for doing it that's evil. Right? The greed to control others. Anyway, it's all paperwork. That's all paperwork. So that's why we put together our estate and we create evidences so that when we go in and it's time to have rights declared, here, this is the evidence. Here's my, the administrative notices that I sent to them, informing them that there's new trustees over this res property. They can't come over and say they had no idea. Right? They've already agreed. Silent acquiescence. Anyway, you administrate utilizing series of notices, right? And you bring back the truth to the record. And the truth is They have no subject matter jurisdiction, nothing left. That property does not exist in their system. Correct the record. So what authority do we have? We have the grantor's authority. In the Bible, we had all that authority. Okay? You act as the grantor's voice, not as the owner. You don't own anything. You came into the world with nothing, you're leaving with nothing. You're just a steward. You're just a trustee of it while it's within your purview, I'll say. Because even our children, we're entrusted with them for a time. They're their own. Okay? But we are supposed to raise them up in the way they should go so that when they get older, they don't depart from it. Well, that's learning to be a good trustee, and you be able to pass that on to your children and your children's children. The Bible also says that if a man that doesn't leave an inheritance to his children and his children's children is worse than a non-believer, right? An infidel, somebody who is outside of any trust. All right. An accounting system, right? The public has a really comprehensive accounting system, which is wonderful when you need to get a full accounting for the things that they've done when that property was within their trust, right? But the accounting is their testimony, right? It's going to speak for itself. Did they do a good job? Did they do a horrible job? Were they wrong in any cases? All that's there. All of that is there. Right? So the accounting, your accounting when doing your trusts and doing your administration is your testimony. Right? If it's clean, if there's no double books or, I know most of us live in some fractional reserve banking system where, they're creating 10 times of the note that you created, right? But they're using your name to do it. How could they do that? Well, the same way my parents used my name and my social to get television service when I was a kid and couldn't even sign a contract, less read one at the time. They do the same thing. Every time we did a promissory note, created money with the banks. So your accounting becomes your evidence. That includes doing your minutes and your administrative, when you're administrating. You keep good records. Right? Here's the deed, here's the quit claim deed, here's the minutes entry, right? Here's the registration certified by the trustees. Those are all evidences. Those evidences stack up, especially when the public couldn't find a piece of evidence with a, with a tracking dog. They couldn't find it. Most of the stuff is presumptions and assumptions, which we'll talk about on Wednesday when we do defending and protecting your trust estate. So when we do our administration, okay, it's not just managing assets, okay, it's protection. It's learning how to take control over managing your own affairs to the exclusion of everybody else that's not a party to your trust. It's empowering. It really is empowering. I'm going to open this up to questions, and I know there's a few people on the call that have taken the courses. So, I'm going to open it up. Anybody have questions, comments here? I'm going to try and get back to this other page. Okay. I didn't shut off anybody's.
Yeah, brother from Harold, actually, he had a question. Harold, are you able to turn on your speaker or unmute, I should say? I don't know if he hears me.
Do you know what the question was?
Anyways, if he doesn't do it, then I'll just kind of ask. I think the question, forgive me if I'm a little bit off, was he wanted, I think, I can't remember how he wanted to know how, if it it's tangible, obviously, like, is it a piece of paper? He's like, am I going to store it in my, my safe vault or whatever? Is it online? Or I can't remember the exact question he had, but I'm assuming it's a piece of paper, right? Obviously, like you said, templates, right? Is
Well,
his
let me,
question.
yeah, I'm going to explain. And I think I got the question. I think I saw that in the chat. I would obviously, I mean, you created, I created digitally. Okay. I have a printout of it. You can print out your minutes. You can print out your banking authority. You can print out the entire estate if you'd like. When I was doing these for people and setting up their estates, it's nice to get a leather bound binder and keep each trust separate, and this way you can keep, it's easy to manage each one of your trusts within your estate. You can go in and get a nice package. They do have. There's plenty of places online that you can order them, and it's just a way of it's an organizer for your trust. They're fairly standard as far as like legal supply stores and things like that. Now, again, a lot of those are probably going to be heavily weighted if there's any substance in them at all when they come. You would be putting in your own trusts, your own documents, and replacing whatever templates they have or whatever they have in there. Usually they're just placeholders. They may have extra minute sheets and which is fine as long as you have a place to keep your record. Some might have an accounting ledger as part of that, and it's just kind of like doing a corporate binder. And you can also get a seal made, right? Just like a business, a business or a corporate entity like the government uses their raised seal. You can get one made up for each of your trusts.
Oh, cool.
Yeah. So that's one thing. And then, having a digital copy, having an original copy, you'll learn all of this, obviously in the courses, but you're going to, you want to have, especially if you're dealing with stuff in the world right now, you're fighting a battle. That case has to have its own file for, do your administrative process. And remember, those cases are bonded. There's an account number. The court is a bank. And this gets back into administrating pretty heavily because, every time there's a case, right, there's another security added, multiple a lot of the times, right? And bid bonds and surety bonds and bail bonds and all these different things that are attached to that case that, if it's a legal issue. But, defending it from a, behind the shield of your trust estate and as a trustee with the only authority over the property, okay, it's a much stronger position to stand, right? Because all you're saying is that, hey, I sent you what this is innocuous. This isn't I'm a driver or I'm not a driver, I'm a traveler, right? I'm not whining and complaining I don't like your rules, but I signed up for them, right? You're saying, hey, you've done a horrible job of administrating my affairs, Mr. State, Mrs. State, Miss State, whatever. And I decided that I no longer trust you in that position of trust. So I've given it the job to new trustees, and this is your notice, okay, that I'm required to send you, okay? And it's your job and your fiduciary duty and legal responsibility to make a full accounting of everything that is held in that name and number. and convey all rights, titles, interests, and actual property, whether it be securities or physical property or, tangible properties or it could be, your own, your own, whatever. It really doesn't make a difference. If it's yours and they're holding it, it comes back. It's conveyed. They quit claim it, any rights, titles, and interests. And it's not that you need them to acknowledge it or quit claim. You're giving them the opportunity to say, hey, you can't do that, and then give you some reason why. Right? If they want to rebut it, if they think you can't do that, then by all means, if I can't do this, please say so. Otherwise, forever hold your peace. And not any single one of them is going to stand up and go, oh, yeah, you can't do that because of this, and this, and I've got evidence to show that. None of them. None of them have that. They don't have it. So we put together putting your trust together and, like a binder, and having a hard copy of it in a safe place is a great idea. Having backups digitally, also a great idea. You may even want to put one in a safe deposit box, a copy,
Right.
So there's lots of, again, it depends on what you're talking about. Not everybody, everybody's at a different levels of where they're at. But it doesn't make a difference whether you're, absolutely wealthy or just getting started, right? You have to start by getting your house in order and then administrating your own affairs. You've got to be the one in control. How can you, how could you be successful unless you're, running the show?
Amen to that. Or so be it. Yeah. Thank you.
Because it's your affairs. You can't administrate other people's affairs unless it's your child, right? And only for a time, because they're going to be under your, guardianship before they're out making their own rules.
Right.
I have a question.
Sure, go ahead.
Thank you so much, David. This is Jacqueline.
Jacqueline.
Bringing up children, we're guardians of our children. At what age does the children no longer, essentially, what age can we,
Can they be
um,
emancipated?
yeah, well, like into our trusts, like as rather than a parent, because that's just renting, from what I understand in the public. But when the living father reclaims their child, my daughter is 19 and I'm in Canada. So is there
Okay.
still time, essentially, or would she have to go through this process herself?
Um, hmm. Well, it's a great question. And just giving that second to think about it, she is old enough to make her own decisions. However,
Correct.
um, what better witness to the birth than you? I mean, if you're
Correct.
saying that you pledged her or registered at her birth like everybody else was doing, um, rescinding that back down to the back and being able to require a full accounting of what's been done in those 19 years with that account, that straw man account that was set up. It's not just an account, it's an entity. It is
Right.
an entity, a legal
Okay.
person. But again, yeah, she's old enough to do this herself, to manage her own affairs. And again, from a biblical standpoint, it was always from, when the parents thought it was, because they were literally turning over parts of their estate, right?
Right.
Part of their property to them.
Oh, yeah.
So,
Yeah. No,
yeah,
so, okay. Well, I appreciate that. I mean, I'm going to start with myself, a living woman born on the land, to And I'm currently going through divorce court, fun times. So that is, essentially my priority for exploring this. Is there anyone on this call that has had an experience or has been able to, in Canada anyways, successfully, um, with authority, change out of the public into the private through the family law, I guess it's called in Canada?
We're in the process because we've been dealing with children family dis services, and I'm just so excited because we're about to free our son from my sister's grasp, who believes the lies of the enemy through children family dis services. So
Wow.
but it's about to happen, but other than that, not fully, but we're there
Okay.
almost.
Okay. And how long is that process? Is that you, JP, speaking? Yeah. Oh, yeah, you're in
Yes, ma'am.
Alberta. Okay. I'm in British Columbia, and I'm not necessarily going through the similar, I mean, divorce is still family law. Thankfully, our
Yeah,
daughter
but
is
divorce,
19. Go ahead.
I would, well, again, going in equity, okay, thinking about this in equity and trust.
Yes.
What's a divorce? What's a divorce? Again, you're in their system of law and statutes where there's going to be arguing. It's an adversarial
Add,
proceeding, that divorce.
oh, is it
And
ever? Yes.
it doesn't have to be. And lawyers don't need to make money, and the courts don't have to have a say in it at all.
That's what I would love. Nothing more.
Well, you have a child, and there's no reason, I mean, you got along to do that, and obviously for a number of years. So to have one good conversation, where you guys settle the matters equitably and fairly, equity does what's right. And if you can get them to see that for long enough to have a decent conversation about it, you can handle this privately without any interference with the public's laws.
And what is, sorry to interrupt you, David. I guess my last question, so I don't take up all your time or others. What is the timeline, even if nobody was dealing with, divorce or child services, or isn't in the throes of, this fictitious public um, entities that, many of us unknowingly and acquiesce, just what is the timeline to get through? Is it like stage one, stage or section one, section two, section three of your course? Is there and
Well,
are things implemented along the way, or do you have to finish all three before you really can
oh no,
implement?
oh no, no. I've I had people, learn this stuff for oh 4 years, and we started backwards there because there was an absolute need to protect and defend. Before we even established anything or administrated everything. We were administrating, before there was ink on a paper,
Okay.
because there was a necessity to do so. That's why I've said that if you understand, you can express this, whether you write it down or you say it out loud and you testify, this is what it is, period. Okay. When
Mhm.
you understand it and can express it, and you really understand who has the authority and who doesn't, it becomes very, should I say, not easy, simple, okay, to walk in
Mhm.
there and you're just doing your job. Hey, it's my job to reconcile. You can't hold me accountable because it's my job. I'm
And
doing
I
what I'm
prefer the
supposed
word overstand instead of under. I've been told that, yeah, they're very clear about, or
to.
understand.
Understand.
Yeah,
I,
I
I know,
understand
I
and I will
know,
overstand.
and I get the babble language that they use and why they do it. It is to deceive, but
Hmm.
doing it this way, you take control over the things that are within your purview, whether it is your children. Just because my kids are all older than 18,
Hmm.
okay, and they have kids, and you know they aren't subject to my rules at all, but they're still beneficiaries of my trust. They're still party of my trust.